Well, with that said, we're going to start the presentation today. And again, the way this started was we got a request from the Georgia Sheriff's Association that there was a need for a records retention policy. And Angela Davis, who is going to be presenting today, wrote that policy for us. And again, you'll be the first to learn about that. We've also sent it to GSA to be able to distribute it to those members. But Angela, if you want to take it, thank you so much, and I'll let you go.
Okay, well, he set me up for this to be really exciting, so I'm sure it's really increased your expectations of this program, and it's probably all fair because this is not an incredibly exciting topic. But let me start by telling you a little bit about myself. I'm Angie Davis, and I have a law firm in Cumming called Girard & Davis, and we strictly do local government. So this is something we deal with day in, day out. We represent a variety of counties, some of which are indicated there on your materials. But we're the county attorneys for Forsyth, Cherokee, Barrow, Jackson, Greene, Newton, Dawson, and recently started representing Henry County. And I think we have someone on from McDonough now, also the city attorney for Milton. In addition to those county attorney, city attorney roles where we do virtually everything for those jurisdictions on a daily basis, we also do special work for folks all across the state, from Bullitt County all the way up to North Georgia, in a variety of different areas, encompassing service delivery strategy, litigation, and really anything you can think of in the local government context, as well as doing work for ACCG through their insurance pool, a variety of other insurance carriers. And also I do the ACCG helpline. If any of you are ACCG insureds, you may know this, but if you don't, here's a plug for the helpline. You have an opportunity to call in anytime you have an employment line question. You'll get me, you can send an email, and our employment team will answer your question and hopefully keep you out of trouble so you won't have a claim. But with that as an introduction, I'll just go right on into talking about what our topic is for today, and that is record retention. Again, not the most exciting topic. I will tell you, when I checked in with Dan to say who has signed up for this webinar, I was bracing myself to hear nobody. That when I heard that even one of you were interested in hearing about this and spending a few minutes with me today about this topic, I was thrilled, and I appreciate you joining in. I'll try to make it as enjoyable as possible. I will say that while it may not be the most riveting topic, I do think it's incredibly important. From a public policy standpoint, the retention of records, public records, are incredibly important because it is how we make a public record and develop and preserve history. So for that reason, you should be very proud of what you're doing and realize how important your job is when you're dealing with records and retention of those records. Now, if that doesn't get you excited, well, then the fact that if we get it wrong, that could give rise to criminal penalties like a misdemeanor. Maybe that'll get you more interested. Honestly, I don't see a lot of enforcement in this area at this point, but that is the downside to not getting this right. So I'm here today to hope that we're going to learn how to get this right together. So what I'd like to do, and my plan for the next few minutes, is just have a casual conversation about records. I want to start with giving you an overview of record retention law so that you understand why you're doing what I'm asking you to do under this policy, what it means. We'll look at some key definitions so you can understand what I'm asking you to do and when it applies. And then we'll talk about the sample policy that Dan mentioned that's been provided to you. You should have all gotten that through an email yesterday, but if you did not, we'll make sure that you get that. And it's a policy that we'll speak about in a little bit, but one that I'm hoping can be a template for you and your organization that you can tailor to your needs. It's not a one-size-fits-all, but hopefully it's a great start for you and your sheriff's office. So with that, let's just jump right in as to the law. So there's something called the Georgia Records Act, and it requires a few things. And one of the things that we like you to do under the Georgia Records Law is to designate a records custodian. Now, if you're on this webinar, my guess is that's you, that you're the records custodian. And I see my clients in various sheriff's offices doing it in a variety of different ways. For some sheriff's offices, it's a full position. There's a job title called records custodian, and you may be that person, and you may do all of the Open Records Act, all of the record retention requirements. But more times than not, in most jurisdictions, I see a scenario where this is the job, part of a job duty, but not a job description and not a sole function. So you may wear a million different hats, and this is just one of the millions of things you're asked to do. and that's a challenge, and I sure understand it. So before we leave today, I'm going to try to at least give you a couple big picture takeaways so that if you don't feel like you can get it all perfect, that you can get the big parts of it perfect, and at least have some takeaways that you can implement. So in addition to designating that custodian, we also have to establish a record retention schedule. That just means a list of how long you have to keep your records. And we give you that in the policy, and I'll talk with you about that a few minutes more when we get into the policy itself. Please know that you can retain anything longer than the retention schedule says. So the Secretary of State through the Archives Division requires this list of retention. So each document is specified and it tells you how long you have to retain it. But with that said, you can choose to retain it longer. So if you are just unable to process any of this, you don't have the time, you don't have the capacity, but you have storage capacity, then you can just keep everything. There's not any requirement that you have to destroy records at a certain time period, except in a few very rare circumstances. But when you do decide to destroy a record, you can only do it pursuant to the retention schedule. So you cannot do it earlier than provided for. If you do, then it's a misdemeanor that can be punishable by law. So now let's look at some key definitions. What is a record? This probably doesn't surprise you if you deal with records, but a record is really just everything, and you should think of it that way. So it doesn't matter if it's paper, it doesn't matter if it's a sticky note, it doesn't matter if it's a paper calendar, or if it's on microfiche, or if it's an audio recording, or if it's a video recording, or in our situations with Sheriff's Office, it could be your dash cam video, it could be your body cam video. Any of those things are all considered records. The retention schedule that's spoken about under the law is simply the list of documents and how long they have to be retained. That's prescribed by law, so you don't have to make that up. You have a set law that's required by the Secretary of State in the Division of Archives, and then this Records Act requires us to follow that list, and we refer to that as a retention schedule. So I'm sure all y'all are really getting excited at this point. So why do we retain records? So hopefully this will help you to feel good about what we're doing. It's all a matter of public policy, as I mentioned earlier. Here's what the law says. It says all records retained or received in the performance of a public duty or paid for by public funds by a governing body are deemed to be public property and shall constitute a record of public acts. So that's why it's important. This isn't our stuff. It's the public stuff. It's paid for by taxpayer money, however it's coming and going, and so we have an obligation to retain it. And sometimes the retention of the materials really has an historical significance. It may not feel like that to you, but sometimes they really do have historical significance. But at any rate, it's not our materials, it's the public's. And if you'll think about it like that, I think you can understand why it's so important. With that said, the retention schedule itself, as I mentioned, is prescribed by the Secretary of State's office. So there's no magic here. There's a list, and you just have to follow the list. That's provided for by statute. And there's a website that you can access, and the website address is also in the policy, where you can go on and look up the list of documents. But we have in the policy already for you the key documents that I think you're going to be concerned about. We'll talk about those in just a moment. Now the big picture here is retaining seems like, okay, not a big deal. It's the disposal that's the big deal. You just can't destroy records willy-nilly. If you see someone standing over a shredder, that should be your biggest nightmare as a records custodian, because you just can't get rid of documents. You can't wad things up and throw them in the trash. You can't shred them unless it's according to a proper retention schedule that follows the law set by Georgia. If you do those things and you destroy them inappropriately, as I mentioned, it can be deemed a misdemeanor. But importantly, if you're ready to quit your job and run for the hills, if you're complying with this law, you're not held personally liable. So they're not coming against your house or your checkbook, and that's important. And it doesn't speak in terms of intentional acts versus negligence. But my belief is if you do the few things that I'm going to talk about with you today and ask you to do in terms of adopting a basic policy and doing a few basic things, then I'm confident that you never have to worry about personal liability. So don't feel like you have to quit your job because this is getting too heavy. I want to talk about just a few general guidelines, and then we'll jump into the policy. This would apply to any kind of record that you're dealing with. And first of all, it applies to all formats. So again, it doesn't matter what kind of form the record is in, the retention is required. These retention requirements, as I mentioned, are minimum. Now, one thing I want to point out to you, if you elect to keep them longer than required under the law, they are still subject to the Open Records Act. So that means if there's a record that you only have to keep it for a year, but you have it 10 years later and you get an Open Records Act request and it asks for 10 years of records, then you're going to have to pull all of those and produce them under the Open Records Act request. So the retention does not let you off the hook on open records. So if you have, as many jurisdictions do, some really aggressive activists out there who are very often making records requests that are broad and they're open-ended, then you may consider that purging your records according to a schedule will really help you. So when you get that records request for 25 years worth of documents, and you can say, oh, I only have them for 2 years because I have disposed of them pursuant to a record retention schedule, then you're off the hook for that other 23 years of production, and it's fully compliant with the law. So that's something to think about if you elect to keep records longer than required. Another general guideline is that these records apply to those records under normal conditions. So I'll give you an example. If you have an arrest report, for instance, that becomes a record that you have to retain according to the retention schedule. But if that same arrest report becomes an exhibit to something in prosecution, or it becomes attached to a subpoena, or it's used for a blow up in court for something in a prosecution, those other forms that you've created that are outside your normal course, those don't become new records that are subject to retention requirements. Those are just used as long as you need them through the prosecution or through whatever use you may have created them before, but they don't supersede or become a new type of record. So just records in the normal course are all that you have to worry about. With respect to when you look at this appendix and the actual retention schedule, you'll see that they talk about retention in 2 different ways. They'll talk about it with respect to creation of the record and sometimes about following the event or occurrence. So for example, accounts receivable files have a retention of 5 years after that document was created, and that's how you have to apply the retention. But bank loans are retained for 5 years after the loan is settled. So that's an event that may occur. And with respect to sheriff's records, very often many of these event-based dispositions are important because it may have to do with the end of a prosecution or when an inmate is released and those types of things. So when you see 5 years, you need to be careful to say, oh, is it 5 years from creation of the record, or is it 5 years from the date of a particular event? Because obviously that could have a very different outcome. So be on the lookout for that. Here's the last thing I want you to know before we jump into the policy, and that's there's something called the Uniform Electronic Transactions Act. This is an OCGA section 10.12.1. And what this act has done is provides that essentially electronic record is just as good as a paper record. So you have to determine how you're going to handle records in your organization. But importantly, if you decide that you're going to go paperless, if you will, or that you're going to have a certain set of your records always be scanned and be online, that's fine. You can dispose then of the paper record. So you can go paperless, and that's okay under these record retention schedules, and it's okay because of this act called the Uniform Electronics Transactions Act. So if you are going paperless, that's fine. You do not need to retain the hard copies with your scanned online version of a record unless you want to have the duplicity just for protection. It's not required under the act. But here's what's important. Very often I see people scan materials, and then when you look at it, you see half of it's cut off or it's so fuzzy you can't see it. Those types of things would not suffice, and then you would need your paper record. So make sure that if you're going to a paperless system, if you're intending that your online record is going to substitute for your hard copy, then please make sure that they accurately reflect the record and that the person who's scanning them online and putting them into your online system, that they are indeed good replicas and are not cutting off material or doing anything that makes them unreadable or to not be a fair representation of the record itself. And then this is important as well. These records, if you go with the electronic versions, they have to be able to be viewed years from now. So some of the records that you'll see have permanent retention requirements. Some may have 40 or 60 years. Some just have 1 or 2. The 1 or 2, you can hope that your software is going to be able to allow them to be pulled up and viewed. But for some of these that you may need to be able to view 50 years from now or forever, you have to be careful that you put it in and take care to put it in this format and then migrate to new formats that you can still read. And I'll talk a little bit more about that in just a minute. So that is the background on the law. I'm going to take a quick sip of my water because I have a little throat problem today, and I apologize. And if you have any questions, please jump right in. We may need another fire alarm to make sure everybody's awake, so I hope you're still with me. So what I'm going to do now is look at the policy. As Dan mentioned, we've provided you with a sample policy. Excuse me. This sample policy is one that we would hope you could adopt, and we think it's an easy one to adopt and then to tailor as you decide you need to for your records. So if there's one big picture here today, I would say if you can do nothing else, then have your sheriff adopt this policy. Your sheriff may do that through bringing it into his standard operating procedures as a new SOP, or it could be a command directive, however your sheriff may operate. But I think it would be important to adopt a policy, because if you ever have an issue, it shows a good faith effort to be doing the right thing by having a policy in place. Now, the policy itself is one that we've tried to do so it would apply to the masses, but it's not a one-size-fits-all. As we get more into the appendix, where you'll see the various records that I've listed out for you, I've tried to be over-inclusive instead of under-inclusive. So you may see records and you say, well, we don't do any of that stuff. We don't do animal control. We don't do code enforcement. I have sheriffs that do. I have sheriffs that do alcohol license permitting. If you don't, then that's fine, and you would just need to go through that list and just cut and splice, delete as you need to. But I thought it better to provide you with more based upon my experience of what I know sheriffs to use than for you to have a record that you don't know what to do with, because I think I've covered probably everything here. But I'm mindful that many of you will need to probably delete some of these records that you don't need to retain because you don't manage them. So with that as the overview of the policy, let's go through each section. It's a very simple, short policy. The first is the policy statement. And really, I don't need to say a lot more about that because I've explained to you what the law is, and this is just a restatement of the law in the policy. So if you're looking at your document, you'll see that it's provided in a template format, so it provides for you to put the name of your organization. So just to make it read easily, I put in Matlock. Some of you may remember that old show with Matlock. So I've put that there just for ease of reference, but obviously you would use that template to put in your sheriff's office name. The statement of policy just states the Records Act law, so it's clear that we're intending to comply, which again, I think so many times if you have a records issue or a challenge, when you can pull out a record retention policy, it shows a great amount of good faith and intention to comply. So that's what we're saying here. We know there's Georgia Records Act, we're intended to comply with it, and we have an Appendix A that sets forth our retention schedule. And remember, when we went through all the legal background, that was something that the law requires, that you have a policy and that you have a retention schedule. So that's what our statement of policy addresses. Looking at the second section of our model policy, it talks about the scope. The policy applies to all of Matlock's officers, employees, or consultants. This is important and may seem overwhelming because it's not just your sheriff and his documents, but it's every deputy, it's every administrative person, it's your corporals, your lieutenants, your detention officers, it's everybody. It applies to all officers of your organization. So again, I say, if you see even your lowest level administrative person or someone that's out in the field on patrol who's destroying records or standing over a shredder, that should make you nervous because it applies to everyone in every record that's created. Again, under scope here, we state what record means, and that's important in this policy because it outlines what the intention is in terms of what we intend to retain, and it's consistent with the law most importantly. Also, it states that it's regardless of form or characteristic of the document. We've talked about that. Again, this policy is drafted so it complies strictly with the law, and that's what's intended by this section 2, where it addresses the scope. Section 3 talks about how it's administered, and this is where you come in. So if you're the records custodian, this is the sheriff, through adoption of this policy, authorizing you to be the records custodian. So I feel like everybody needs to get a big shirt with a big R on it because you're the superheroes of records retention. This policy, the way I've drafted it, authorizes you to do certain things. It's listed here 4 particular things. Obviously, you could monitor, you could revise this to provide for anything that the sheriff wishes you to do in this field, but I think this is the most likely levels of duties that you should have as a records custodian. The first thing is that you're retained and you're authorized to modify the retention schedule. So if you're monitoring updates in law, if we send you an update, then you have the authority to go in and change retention schedules as needed for the policy. Number two, you would monitor the laws that would affect record retention obligations. It may not be just the record retention law of the state of Georgia, but there may be something new that comes out with GCIC, through the GBI, or through CALEA, if any of you are CALEA certified, that you need to monitor and know how that may impact your retention schedule. I think most importantly is number three, you need to annually review and have some kind of schedule for disposition of these records. That's the most important part, if you can get time to do it. And I understand if this is not a full-time gig for you, it may be hard for you to find time in your job duties to do it, but I think that's critically important. If you can have a set-aside time annually, maybe the first of the year or the end of the year, where you review your records globally, you review your record retention schedule, and you determine what can be purged. If you have particularly space issues, either physical space or online space limitations. And then finally, it's your job to monitor compliance with this policy based upon how I have authorized your duties here under this policy. And by that I mean being sure that you're educating the folks within your sheriff's office. Many deputies, many administrative people will not realize how important every piece of paper they create is. It's not intuitive for them to know those things. And so please make sure that they understand and have some training within your department where you share with them the policy. Perhaps it's just sent out as a part of an SOP or a command directive, that people are aware that these records are public records that must be retained so that they are not shredding and they're not throwing things away in the trash. When you look at the retention schedule, I've explained in the policy what the schedule means, and that's in section 4 of the sample policy. When you look at that Appendix A, you'll see there's a columns that go across. First, there's a title of the record, and you may be surprised at how very specific and detailed these listings of records get, and we'll get into that in more detail. There's a description briefly of what that record is if it's not obvious to you based upon the title. Then there's the retention period, and again, remember to look to see if it's based upon creation of the record or whether it's based upon the event. Give me, please. This is where we need another fire alarm or Dan to start tapping and things.
Well, let's see if there's any, while you're out there, does anybody have any questions thus far? Anybody have anything they want to talk about? So give Angela a little break. Let's see.
Nobody out there? Well, I can understand. It's honestly a pretty cut and dry topic, and so I'm not surprised there's no questions at this point. There's essentially a list to follow, and I apologize that I have a terrible cold today. The last column there is a number, and this is a specific identification number designated by Georgia Archives. That's a number that you're probably never going to care about unless for some reason Georgia Archives is approaching you to learn about your retention schedule or to seek the compliance report. Now, section 5. The identification and categorization of records is addressed in this section of the policy. I want to point out a couple of things here in the policy, and you may very well want to change this. It's all dependent upon how your sheriff approaches records. I have some sheriffs who think it's a real inconvenience to have an Open Records Act or any retention requirements whatsoever. And I can certainly understand and relate to that. You're in the business of law enforcement and public safety, and some of this administrative stuff is tiresome. I totally understand and appreciate that. I have other sheriffs, though, who really like to err on the side of caution to make sure they're complying strictly with the records requests and strictly with record retention. So this policy has been drafted for those sheriffs who really err on the side of strict compliance and extra care. So what we say here is that if you have duplicate records, that you will maintain them in duplicate form. And what I mean by that is many things that you come in contact with may also be retained elsewhere within your county. Say, for instance, you may have payroll records, you may have leave requests, you may have other HR-based documents that are also maintained by HR. If they are, then you may decide, I don't want to keep duplicate records. We don't have the space to do it. I'm not interested in doing that. And if the duplicate records exist elsewhere and they're being preserved according to a retention format, then that's fine. This policy says you're going to retain them in duplicate in an abundance of caution. So consider that if you adopt this policy, that you may want to modify that depending on specifically how your sheriff wishes to approach it. Duplicate records are not necessary, But remember that you have an obligation as a records custodian to know that they're retained. So if you're not going to duplicate, then I say document. And by that I mean, if you're going to depend on HR to keep those HR records, or maybe your planning department to keep the permits that you may not need to have, but you may have some involvement with and have in your office for some reason, or any other type of record like purchasing. Your purchase department may have contracts that the sheriff's entered into, or bid issues with respect to the sheriff's and his purchase of equipment and cars. If purchases maintains that and you don't want to, that can be okay under record retention. It's important that they have to be retained. So again, if you're not going to duplicate, then document. Document with those other agencies of the county. Document to HR that we understand that you're retaining these records and therefore we will not. Document to the purchasing department, or document to planning, so it's clear who is catching the ball. So if you need to say, I'm not it, you're it, then do that, but do it in writing and make sure that you're clear between the two agencies who is retaining it, because the worst thing of all would be for the other to assume that the other agency's doing it and then everybody's out of compliance. Another point I want to mention is that if you have a record, if you have a piece of paper, or you have an audio tape or a video, and you don't know where it fits into the list, while the list is very specific, there's obviously an opportunity that you can come up with something that doesn't fit strictly in the list. If that happens, you can consult with counsel to see if there's a logical place that the counsel would believe it fits, and you're welcome to call me and ask me that question. Or you'll see a website there that I've given you, and that's the Archives Records Division, where you can reach out to them, explain what the record is, and their records committee will tell you where it fits. And sometimes it ends up creating a new entry on their retention schedule. So if you have something that you're not sure where it goes, reach out and find out. It doesn't mean necessarily that you get rid of it just because it's not on the list. It sounds like we might have a question.
Question, is there any way to be notified when the retention schedule is modified?
Well, that's a great question. Unfortunately, I don't know that there's any protocols that allow for that. Just like when a law gets amended or changed, boy, we as lawyers would love it if someone would knock on the door and tell us, look, this has been changed, so make sure that you follow the new law. There's not an update or an alert from the Secretary of State's office that I'm aware of. But that's certainly something that I can talk to Dan about and see if we can provide some monitoring assistance for you to let you know. Because I think that's why we're here, is to try to help you do your jobs better. And that's why we're doing this policy, is because the Georgia Sheriff's Association had indicated some concern and questions about it. So we'll look into that and see whether we can monitor and provide you with updates. I can tell you that the last updates, and you'll see this in your Appendix A that you've got in front of you, I think the last time most of these have been updated and looked at was like in 2017. So it's not something that they're doing annually or terribly often, but that's a great question. And we'll look into that a little further and see if we can help out with that. Any other questions before we go on? Okay. Thank you. All right, so Section 6. Here's some general guidelines. Some of these mirror the guidelines that we spoke about when I was explaining to you the law, so I won't reread them to you. But I do want to make a point about a couple of things here. In the policy, it specifies that if there's a conflict regarding a record retention period, always retain it for the longer period of time. And our policy says that that's what we're going to do, and that's definitely my recommendation. So if you find that under CALEA or something to do with respect to a GBI retention requirement, that it's a lesser requirement, err on the side of complying with this retention schedule that has the longer retention period. You can't go wrong if you do that. We talked about the fact that normal business conditions is how you retain the record, and if new records are created, that they don't necessarily have to be retained in their new form. Again, if you have litigation that comes into play, whether it's a prosecution or whether you have an employment claim, as you have some employment litigation, or you have a workers' comp claim, then it's really a game changer. So what I would suggest in that case is that you talk to your counsel that's involved, because very often you'll get what we call a spoliation notice that'll say don't destroy anything, freeze everything, and you need to comply with that. So just because the retention schedule may say that you can get rid of this employment file at this time, if you've got litigation involving that employee related to an employment issue and you've got a spoliation notice, or even if you don't, if you've got pending litigation, then you need to be talking to your county attorney or whoever's handling that case for you to know and make sure that you can dispose of that document. Probably you couldn't and you should not. So just know if litigation is ensuing or prosecution is ongoing, then that should be a red flag, just to freeze, don't touch any of the records involving those pending items. So section 7 of the policy then gets down to the nitty-gritty about disposal. And it provides that no record can be destroyed unless it meets the minimum retention period. Importantly, when you dispose of records, you should retain an accurate log of what you destroy. So you don't want to just go and just purge and throw away and delete when you have the opportunity under retention schedule. Instead, you need to create a log so you have a list of the documents that you have, the records, and what you're getting rid of. That way, historically, we've preserved that and you keep the logs. That way, if there's any question ever, did you retain it long enough, you can show, yes, I had this document on this date, it complied with the law, and I don't have it anymore. And that's particularly important in terms of litigation and in terms of the Open Records Act. So if you get a request for a record and you say, I don't have it, many times that can spur on an attorney general complaint, or if it's in the context of litigation, they may try to draw negative conclusions to say, aha, they're guilty, they're wrong, that officer obviously used excessive force because all of a sudden the body cam video is gone. But if you've done it according to your retention policy and you've logged it and can show in your log, I had this record, I disposed of it on this date, it complies with the retention requirement, then in litigation, you're not going to have a negative consequence based upon that disposal. And if you get a complaint under Open Records Act, you're not going to have any liability there as well. So that's why you do the log. It's very important for protection of yourself when you're disposing many of these records. Now, this is the place in the policy that I think you may have the most need to tailor to your own needs. For many of you, you may say, we can't handle all of these different retention requirements. I can't keep straight the 1 year versus the 4 years versus the 10 years versus the 50 years, and that's understandable. You may say, I'm going to keep everything until I'm going to review it in 5 years from now. I'm going to review it in 10 years from now. If that's how you tend to approach it, and you have the luxury of having the space and the resources to do that electronically or physically, that's fine. But I would suggest you put that in your policy, that that's what your plan is, that your plan is to review records in 5 years to determine a purge. I think I have a question.
Got a couple questions. With implementing a new policy where one doesn't exist, does the record that can be purged based on the new policy get purged, or does the timeline only apply to records created after policy is implemented?
Great question. I'm afraid I'm going to give you probably the answer you don't want. But whether you have a policy or you don't have a policy, these retention requirements exist. So it would absolutely apply to all of the records from the beginning of time until now. So unfortunately, you can't say that there's a bright line and then you go forward. Instead, again, even if you didn't have this retention policy in place, you're still obligated to follow the law for retention. We're suggesting this policy so that you have something to share with those in your organization so everybody's aware of obligations, and also to show your good faith efforts to retain. But it doesn't draw a bright line in the sand that allows you to somehow start retaining before you have it. I think I have another question.
Got some more.
Great.
How specific does the log need to be?
The log. I don't think it has to be incredibly specific. What I would suggest doing, well, of course, the more specificity, perhaps the better for you. It depends on the context of the document. But for instance, if you're purging incident reports, then I would put the name of the defendant or the potential defendant. If it's policies, that you're getting rid of various policies or internal administrative type documents, I would give it some kind of label with a date, just so that you know if you're ever called upon to produce that document, that you can definitively go back and say, no, I have not purged this because I'm guilty, or no, I have not done this in violation of the Open Records Act, because here it is, here's the name of the document, and here's the date on which I purged it. So my suggestion would be to set up a column, very much like the column in the Appendix A for the retention schedule, where you name the document, you describe it. So it might say incident report, give a brief description where it talks about the date of the incident, and maybe there's a variety of perpetrators involved, or the complainant or the victim. Put some basic identifiers in that place of description, and then the date on which you purged it. So I think if you have that, I would do it in a chart format. I think that's plenty. But I do think if you don't have enough identifying information, then it won't help you to come back to it. So if you're contemplating, hey, I'm just going to say incident reports purged on this day, that's not going to help you a lot if you ever have to come back and prove that you had something for the length of time that was required.
And one more question.
Okay.
If you store your department's records with your county record center and signed a policy statement with the record center, and the record center follows the state archive procedures and retention schedule, should you still have a policy for sheriffs also?
Well, if you have the ability to do that, good for you. That's awesome. That means your job is made much more easy if you are able to send it out to the county to have a clearinghouse to maintain it. What I would suggest you do, though, is to still adopt a policy. The reason I say that is because there's very particular laws that put on the sheriff certain burdens, particularly with respect to dash cam video and some things like that. So I think it's important to have a policy for the sheriff's office, because when the sheriff gets sued and it's that excessive force claim and we're looking for that dash cam video or that armor video, it would be nice for the sheriff to be able to pull out the policy and say, here's my policy and here's what we do. But then I would have that documentation with the county clearinghouse that they're taking on these responsibilities for you. But I do think a policy would be helpful. But in that case, you would be designating the county as the records custodian and not yourself or anyone within the sheriff's office. I hope that's helpful. Okay, so disposal, again, when you're disposing of them, again, I would suggest you have the log that you can go back and look at. And then when you destroy records that are sensitive, that are confidential, if they're HIPAA-based documents, or if you have a police report that has medical information in it, or privacy-based information with victims, children, those types of things, please make sure that you do dispose of them in a confidential and secure manner. So if you have those documents that we had to protect when they were existing, it's not good enough to just go throw them out in the dumpster where anyone then can see them, because then you can bring some liability on your agency because you haven't maintained that confidentiality and security of those records. So in those instances, that's when you get to pull out the shredder and make sure that you get rid of them in a secure and confidential manner. So however you retain them, make sure you dispose of them in like manner to make sure you protect confidentiality and important private and sensitive information. Again, we've talked about that under the Records Act, and the policy states it here that you may retain longer, but I think you should consider that when you adopt your policy. And again, this may be another issue that you want to tailor in your own policy as to what your plan is. Will you retain longer or will you not? And the reason I say that is because when you get that Open Records Act request, invariably, they're going to expect you to have the record. But if you can go back and show, hey, I'm disposing of this pursuant to this policy, it's gone, and it was done according to the retention policy, then that's very helpful to you when records are being requested by outside parties. Section 8 gives a couple of additional notes that are important for your retention policy. I mentioned this earlier. Some of the retention periods are very long, and so if you are an agency that's going to a paperless system where your records are electronic, it's incredibly important to make sure that you don't have them dumped down on a server or in some kind of ancient, archaic technology that you can't review next week, let alone 40 years from now. So it's important that with hardware and software changes that you have your records in a system that can have periodic migration and transfer of records to new stable preservation methods. I had an Open Records Act request recently for a client, and we had the record, and we were supposed to have the record, but it was based on an old software in an old server that was maintained. But in order to get that document out, we were going to have to go through thousands of dollars of restorative work because they had not done a migration at the time. Ultimately, we were able to talk the requesting party into narrowing that Open Records Act request so that we didn't have to go through that production exercise. But if you're supposed to have it and you don't have it in the form that you can share when it's requested, then that expense is going to fall on you. So it's very important that as you go along and think about if you do new IT upgrades, you as the records custodian needs to have top of mind Okay, wait a minute, that's great, we're upgrading, what about this other stuff back here? So think about no record left behind, because it's important that you be able to carry those forward in a manner that they can always be able to be viewed and preserved. The Section 9 of the policy talks about what happens if you violate the policy. Under the law, we've talked about that can be a criminal misdemeanor. If you're outright destroying, falsifying records, that can be a felony under certain circumstances. But also for your perspective, it's important to note, and I think it's important to have in your policy, that it could be a personnel action, disciplinary action up to and including termination. So if you know you have employees who are not retaining records as they're supposed to, or maybe intentionally destroying records, then at a minimum, it could be a disciplinary action with those employees. But just like with any disciplinary action, it's important that the employee be on notice. So that's another reason to that question about should we adopt it as a sheriff's office if I've got my county doing it anyhow. Another reason I would say yes, because it's a place where you're retaining a rule that says you can't destroy records, and then you can go back to that to use for any future disciplinary actions. Again, though, it would be important that this policy is shared with the officers in your organization so that they know that this is a performance standard that they're going to be held to. The last thing I want to do, and I'm almost done, is to look at the appendix. So I'm not going to go through all the pages. Appendix A is what is the actual record retention schedule. Now, when you look at this, you will notice that I have carved out what I believe to be the most pertinent records, as I mentioned, that you may have in your sheriff's office. If you see the Division of Archives retention schedule, it has a slew of other records that would not apply to you, I don't think, under any circumstances. So I've tried to narrow this down so that it would seem somewhat manageable. So what I would suggest is at some point, some night that you can't sleep, get this out and go through it and just start marking out what may or may not apply to you. And then just delete those things. As I said, if you don't do animal control, if you don't have a K9 unit for your department, if you don't manage your own HR, if you don't do permits or licenses, then all of those things can drop out and then it becomes much more manageable. But otherwise, I think it's important for you to see the things that have to be retained to make sure that you do retain those if you do come in contact with them, or as I mentioned, if you're not going to retain and duplicate those efforts, that you document with your HR department or your license and permits department or with your purchasing department. So this is an example of one of the appendix pages. And if you look on the far column on the left, you'll see, and this is one of the pages in your Exhibit A, you'll see there the very detailed list of documents, probably far more than you realize, and the distinction of documents. So there's arrest warrants, but there's also recalled arrest warrants. Let me go back to this page for 1 second. And so they're very specific even within a general category of documents. And then you look at all the different years. You've got 1 year, you've got 5 years. With arrest warrants, it's 3 years after court appearance or 50 years for capital offenses if it's an open document or open arrest warrant. Excuse me. Take a look just for a second at all the distinctions. And a question about now would be great, but I don't think we have any, right?
No questions at this time.
I apologize, guys. Thanks for bearing with me. But I put in a couple of these pages of the appendix for you to see because I wanted to highlight to you just how specific these record retention schedules are. And let me go to that last page. There we go. So here again, you see distinctions for criminal investigations dealing with capital felonies different than felonies, different than misdemeanors. So you can't even just categorically in your mind say, okay, criminal investigations, I'm going to memorize this. I know it's going to be 7 years. No, it depends on what kind of crime it was. So it could be 50, it could be 7, it could be 5. Very, very different periods based upon any kind of different document and then distinctions within the types of documents. So let me say this to you. Don't for a second try to memorize this. If you ask me a question about how long do I retain a certain document, I would do exactly what you're going to need to do, and I would pull the retention schedule out and I would have to look it up because it's just not incredibly intuitive and you certainly won't be able to memorize it all. But what I think is important is just for you to know that these categories exist. And just to know that if you have a record of any sort, it's going to fall into a category. And if it doesn't, then what are you going to do? You're going to check with the archives department to figure out where it should be plugged in. and you know that it has a retention schedule of some sort. One last thing I want to mention to you is in this appendix, in some respects, you'll see reference to retain for useful life. I'm often asked, well, what does that mean? Well, what I think that means is you decide. So I don't think they can come hit you over the head with a hammer if you have disposed of something that has a retention for useful life, because that's a determination that you're free to make. So in many of these things, I think it would be in the normal course of business, how long would you keep them? If it's a particular log or something, once the log's filled up and you don't have any more room, then maybe you discard it if that's a useful life retention period. So that's how I would approach those, is that it's a discretionary decision for you to make as to what makes sense in the ordinary course. So that is our whole policy and presentation, and I thank you for your patience. I would like to leave you with a few thoughts, because it is a little bit overwhelming, if not mind-numbing, I know, in terms of what you're supposed to do with these record retention laws. I would say this: I would recommend you adopt the policy, have your sheriff do that in some official manner, that you circulate it to your employees so that they're aware of it, and then you determine internally what's workable for you and modify the policy as you need to in order to do that. Again, it may be we're going to just retain everything, at least for a while, maybe until there's some software developments that will help us to do this. Or you may determine we're going to look at this once every 5 years and make a decision. Or you may be able to say we're going to do this annually. Obviously, an annual review is ideal, but I'm mindful that that's not always possible with limited resources and limited staff. But I would say do the best you can, adopt the policy, and just don't destroy. That's what's important. Don't destroy records. Make sure that you're only doing that once you know they've been retained. But if you're unable to review and make those decisions on a periodic basis, don't beat yourself up over that. Just make sure you're not disposing of them too soon. That's really all that can get you in trouble. So if there are no other questions, that's all I have for you today. But I would welcome you to reach out to me if you need to, once you digest all this, once you get into the policy. If you see that you need to alter it, but you're not quite sure how, then feel free to give me a call. You've got my information there in the policy and on your materials. I'd welcome you to reach out, and I'll help you with tailoring it to your own needs.
We have not a question, a comment. Thank you for your time. Any other questions? Great webinar and information. Thanks. Thank you so much. Some applause, I guess. I would have a question for you. So, what are some of the risks of maintaining records for too long?
I think that's a great question. Well, there is one GBI, and I think this is referenced in your policy itself that I didn't mention, so great question, Dan. There is a GBI rule about criminal histories. When you pursue or when you get criminal histories in connection with licensing decisions, the GBI asks you to purge those as soon as you don't need them any longer. So sometimes there's going to be a particular quirky rule like that that says get rid of it when you can. The other difficulty or the other danger to keeping them too long is, as I mentioned, is the Open Records Act. Some of you may be blessed not to have Open Records Act requesters out there. We like to call them activists, government participators who make requests daily and just take up your time. If you don't have that problem, I'm happy for you. But so many of you, and some of you that I know on the other end of this camera, I know for a fact that you do have those people that really, really are a drain on your resources. So when you get those outlandish open-ended requests for 20 years of documents, and you still have 20 years of documents, then you got to produce them because you have them. So if you retain longer than required, they are subject to the Open Records Act request. But if you purge, then you can say, well, guess what? I don't have 20 years of records because I can purge after 2 years. I've done it. Here's my log, as you remember, to show you that I've retained until I had to. I disposed, and here's my log. So Open Records Act requester, sorry, you're only getting 2 years of materials. So that's, I think, where it'll help you more than anything.
Very good. Well, thank you so much. We really appreciate it. Thank everybody on here. Lots of great questions and comments. Thank you for your activity. I'll be sending out probably today or tomorrow morning the recording. I'll send out the policy again, and I'll send out the presentation. But don't hesitate to pick up the phone and give me a call if you have any questions. Thank you so much, and have a great rest of the day.
Thank you. Apologize for the throat, but thank you.